People of the city of Taylor versus Randall Crane. Good morning. I see Mr. Crane up on screen. Sir, I believe you are muted. If you could unmute, please. Good morning, sir. Would you state your name, please?
My name is Randall Timothy Crane.
Good morning, Mr. Crane. And on behalf of defendant, today we have, please.
I'm the House Counsel. I spoke with Mr. Crane. We had a breakdown in communications. I don't believe I can go forward representing him. We do not support the same theory of law.
Mr. Crane, sir?
It's always unsettling to see a defense attorney back out in real time. You can sense the tension as Mr. Crane realizes he's now standing alone before the court. This moment shows how quickly legal representation can collapse when a client insists on unconventional or sovereign interpretations of the law. The judge stays calm, but you can already feel where this is going.
You have the right to have a court-appointed attorney. Do you wish to have a court-appointed attorney, or are you going to represent yourself at this time? You could change your mind later on, but at this stage, sir, are you representing yourself?
Me and the House Counsel do not agree on a bunch of things.
I understand that. My question is, all you're here for today is I'm going to actually give you the formal arraignment and conduct a pretrial. All I'm wondering, sir, is are you going to represent yourself at this limited proceeding? That's all, sir. Okay. All right. But at this time, we do not have other...
What's striking here is Judge Chewing Gan's patience. He doesn't rush, doesn't mock, just explains line by line what an arraignment means. This is what a good judge looks like when faced with confusion, clarity, and control. Many sovereign citizen style, defendants reject these basic explanations. They focus so hard on challenging jurisdiction that they miss the real point protecting their rights by understanding them. Ironically, that misunderstanding often becomes their downfall.
What I am going to do is what we call an arraignment. All arraignment, sir, is just a formal reading of the charges that are lodged against you. That's all it is. And I explained that the rights that you...
Well, I understand my rights.
Hold on just a minute, please. Hold on just a minute. I want to make sure I have the complete file. Zicki, maybe you can offer a little assistance, sir. Okay, no, I've got it. So, for the record, Mr. Crane, you're here for an arraignment. As I explained, sir, initial stage of the criminal proceedings, or simply put, you're advised of the charges that are now formally lodged against you. I'm going to advise you of the rights that you have. You plead, after I'm done with that, then you plead guilty or not guilty. After that, sir, the next stage is something called a pre-trial conference. That's where you, if you're representing yourself, or you with your court-appointed attorney, you sit down with the prosecutor and discuss the merits of the case. Okay, sir. So in this matter, you are charged on the complaint of Taylor PD Officer Schillenberg, who states that on March 26th, while in the city of Taylor, instructed the officer from performing his lawful duties, specifically with respect to the stop on where he claims he observed you operating electronic device. Now, a misdemeanor charge in the state of Michigan offense, it subjects you potentially to be 0 days in jail up to 90 days. Fines could be 0 up to 500. You could be placed on probation also for a period of up to 2 years. Of course, you have the right to have an attorney to represent you. If you can't afford one, one could be appointed. Of course, you start out with the presumption of innocence. You close with that presumption all the way through, unless and until a jury finds out or a judge rules the other way. Now, of course, you have the right to have a trial. The trial could be heard by a jury or a judge. At trial, sir, you and your attorney have the right to cross-examine all of the prosecution's witnesses. You could bring in witnesses that would testify on your behalf. and you can testify or not testify as you see fit. If you choose to remain silent, it can never be held against you. For example, you could never tell the jury that, oh, you must be guilty because you didn't testify. We don't allow.
Where the courtroom energy shifts. Everything seems to be wrapping up smoothly until Mr. Crane suddenly says he doesn't understand and then turns the proceeding into something surreal. This is where frustration and ideology collide.
You have to prove your guilt beyond a reasonable doubt. Now, having heard that charge, how do you plead to the charge of obstructing the officer? I'm going to note that the defendant stands mute. Has the same effect, sir, as you pleading not guilty. Now, sir, you are going to have I need you to write this down, please. You will have a pre-trial conference where you're going to meet with an attorney here in the court. Write this date down, July 16th at 9 a.m. It's an in-person pre-trial conference. Furthermore, sir, we're going to mail a notice of that date to the address that's listed on your ticket. Not going to state the address now because this could go out for further public consumption. Not going to do that. But note, sir, July 16th, 9. And at this time, I'm going to release you on a personal bond. You don't have to post cash. That's your word that you're going to come back on the July 16th date at 9 a.m. All right, sir. Now, I also want to inform you, we have a couple of other charges. They're called civil infractions. One has to do with no proof of insurance and no registration. Sir, these being civil infractions, you can't be sent to jail for these. They're simply not criminal offenses. All right. You'd be fined up to $100 on each of those, but you can't be sent to jail. Just for your information, they are accompanying charges. So again, sir, today, we're requesting appointed counsel. I'm also noting for the record, you had spoken with Mr. Kazicki, and he's not able to represent you.
That last line, I will be charging the court $1,400 for my time, captures the essence of sovereign defiance. It's not anger. It's delusion wrapped in confidence. These defendants truly believe they can build a court or reject its authority, not realizing how powerless those words are inside a legal system governed by facts and statutes.
And lastly, again, you're on a personal bond. That's your word that you're going to come back on that July 16th date. Understood, sir. Now explain it again. You come back on July 16th in court for a pre-trial conference. You meet with the attorney who will meet with the prosecutor. That's when they discuss the merits of the case. And right now, I've released you on a personal bond. You don't have to come to the courthouse and post any money. It's your word that you're coming back on that date. I've notified you here on the record of the court date, and further, you'll be mailed.
Your Honor, I understand that part, but what I don't understand is I don't understand the jurisdiction that the court has over me.
Sir, you're going to be able to discuss that at a later date. This was just to advise you of the charges formally lodged.
Well, I would also like to advise the court that every day that I am in court, I require $1,400, and I will be charging the court $1,400 for my time.
Sir, you can do as you see fit on that count. I'm just apprising you of your court dates. And with that, you're free to leave the meeting.
What's fascinating, though, is how Judge Chungan responds. No sarcasm, no shouting, just calm dismissal. You can do as you see fit. It's the quiet professionalism that wins the day. Cases like this remind us the courtroom isn't a stage for belief systems. It's a place for truth and accountability. And sometimes the most powerful moment isn't when a judge yells. It's when they simply let the absurd speak for itself.